Case 43, Air France versus Saks. We find ourselves in the Supreme Court of the United States. Facts. Respondent, while a passenger on petitioner's jetliner, as it descended to land in Los Angeles on a trip from Paris, felt severe pressure and pain in her left ear, and the pain continued after the jetliner landed. Shortly thereafter, respondent consulted a doctor, who concluded that she had become permanently deaf in her left ear. She then filed suit in a California state court, alleging that her hearing loss was caused by negligent maintenance and operation of the jetliner's pressurization system. After the case was removed to the Federal District Court, petitioner moved for summary judgment on the ground that respondent could not prove that her injury was caused by an accident within the meaning of Article 17, the evidence indicating that the pressurization system had operated in a normal manner. Relying on precedent that defines the term accident in Article 17 as an unusual or unexpected happening, the District Court granted summary judgment to petitioner. The Court of Appeals reversed, holding that the language, history, and policy of the Warsaw Convention and the Montreal Agreement, a private agreement among airlines that has been approved by the federal government, impose absolute liability on airlines for injuries proximately caused by the risks inherent in air travel, and that normal cabin pressure changes qualify as an accident within the definition contained in Annex 13 to the Convention on International Civil Aviation, as meaning an occurrence associated with the operation of an aircraft. So what's the issue? Whether liability under Article 17 of the Warsaw Convention arises if a passenger's injury is caused by an unexpected or unusual event or happening that is external to the passenger. Holding, the judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. Reasoning. Liability under Article 17 arises only if a passenger's injury is caused by an unexpected or unusual event or happening that is external to the passenger, and not where the injury results from the passenger's own internal reaction to the usual, normal, and expected operation of the aircraft, in which case it has not been caused by an accident under Article 17. The court noted that any injury is the product of a chain of causes, and the court requires only that the passenger be able to prove that some link in the chain was an unusual or unexpected event external to the passenger. Until Article 17 of the Warsaw Convention is changed by the signatories, it cannot be stretched to impose carrier liability for injuries that are not caused by accidents. It remains our duty to enforce the treaties of the U.S., whatever they might be, and the Warsaw Convention remains the supreme law of the land.